3,644 days. 75%. What do these numbers mean for Nevada's children? There are 3,500 children currently in foster care. These children are in care for an average of 644 days. 75% of the children in Nevada foster care are under the age of 9. When children are removed for abuse and neglect, it is traumatic, confusing, and overwhelming for the entire family. The courtroom feels foreign and adversarial, but there is an alternative to the courtroom, a way to help families work with the dependency process: mediation. Mediation offers a collaborative approach to dependency cases, allowing them to move forward quickly without having to go to trial. The environment in mediation differs greatly from that of the courtroom.
Mediation is a tool increasingly used by courts to resolve cases early and effectively.
The population of litigants that we have in our foster care cases is often very disadvantaged in terms of education and a lot of other barriers, and the courtroom is a frightening place. It's an intimidating place. It's a place when the parent walks in, everyone else seems to know who everyone else is and why they're there and what they are to do. And they are inserted into that environment at a time of total crisis and fear. Their children have been removed from them. Mediation could not be more different. It is structured to be relaxed and welcoming, to encourage their voice. In the courtroom process, there are all kinds of rules of which the litigants are unaware. In mediation, the rules are basically human civility, that we let people have turns at speaking and we don't interrupt one another there. It's an experience that is not foreign and not frightening. It's hard in a courtroom process for a judge to understand what a litigant wants most.
Dependency hearings are really hard for parents. They're quick, it's a foreign place, and lawyers are often talking on behalf of the parents. I think parents kind of lose their voice in that process. They don't get to just stand up in court and say, "Your Honor, let me tell you what happened here. Here's everything that's important to me." But mediation, it really is that opportunity. They can sit down with the social workers, with the district attorney, CASAs, whoever's involved in the case, and really share their perspective. And they can also listen to this perspective of others. That's just something that you can't get in the courtroom that mediation really offers.
Mediation allows everyone involved in the case: parents, social workers, attorneys, CASAs, and sometimes the children themselves, to meet in a safe, confidential environment to discuss the case and find ways to resolve it.
Another important aspect of mediation is that it allows both sides to actually see and hear from the parent and from the district attorney, and it allows them to come face to face in not as hostile of an environment as a trial would. And so I think what's important is that for my parents, having the DA and the social workers actually hear their stories and hear what they've gone through and hear what they're going through is a really important aspect of humanizing the client. And so I think that mediation offers that ability.
Because everyone in mediation signs a confidentiality agreement, it opens the lines of communication.
Mediation is also important with regard to parents being able to be open and honest, because when we enter that mediation room, everybody's signing a confidentiality agreement. And after that's signed, I do think parents think they can be very open with what's going on. In mediation, things remain confidential, and so they are able to say, yeah, that happened, but this allegation's wrong, and here's why it's wrong. This word's wrong, or the name's wrong, or the amount of beer cans you found in my house was wrong. And so they're more likely to look at the allegations in the petition and be very open with what's true and what's not. because otherwise, if we don't have that forum, they're much more likely to stay quiet until the evidentiary hearing because they don't know what it's okay to say and what it's not okay to say.
Mediation also encourages options for resolution beyond what a court could order.
If you have a good mediator, a collaborative relationship in that room at that moment to try and prioritize the strengths and minimize the vulnerabilities of the family, then you really have the opportunity to explore different and unconceived alternatives to what the menu is in the courtroom.
The mediation process allows parties to build relationships and find their own solutions, which helps parents become more engaged in their case.
Mediation humanizes everyone. Parents can sit across the room from me and also realize I'm a human. I'm not just the DA who's trying to take their children away from them. I'm a human being who understands and empathizes with their situation as well. In a recent mediation, I sat across from a mother and I told her, I don't want to take any more of your children from you. And she responded that I believe you, and that's the first time I've ever believed a DA that's told me that.
So after they engage in the process, they tend to get more engaged in their case, and whether that's fulfilling their case plan, going to individual counseling, or doing a substance abuse evaluation, it's my opinion that after mediation, they feel more comfortable in doing that, and they feel more comfortable around their social workers, and they see the process not as adversarial as the process when it began, but more as a teamwork to help them get their children back, which is the whole goal of dependency case.
We had one case where a dad was continuing to smoke methamphetamine, and the DA just didn't understand it. And he said, "Did you ever smoke cigarettes?" And she said, "Yes." And he said, "Do you still want one?" And she said, "Yes." And he said, "You got it." And the DA sat through that. That would never happen in a courtroom. And he felt like he had gotten a bit of human-to-human interaction as opposed to a judgment on paper.
Mediation can change the trajectory of a case. Disengaged parents become engaged parents. They develop trust with social workers, they understand the system better, and they can start working their case plans and really focus on what's important, which is reunifying with their kids.
Dependency mediation takes place at any time in the case. It's most commonly used at the petition, placement, and TPR stages. At the petition stage, mediation allows parents to get past issues surrounding the removal and move forward with their case.
One of the benefits of mediation is a chance to lay the groundwork for a relationship. Especially when we're talking about petitions, there's a relationship that's being formed between the social worker and the client. They're going to have to work together for 3 months, 6 months, 12 months, 18 months, and you're setting a different tone than has been set with the removal.
Remember one case I had at the petition stage. The children were removed because the father wasn't watching them closely enough at a really crucial time, and something bad happened to the kids. So the petition said that when this event occurred, the father was asleep. When father came to mediation, he was adamant that he wasn't asleep, he was in the shower. So the DA agreed to change that part of the petition to say that he was in the shower, and with that, Dad submitted to it. It wasn't material whether Dad was asleep, whether he was in the shower, but for the father, that was incredibly important. So once he was allowed to put that out there, the mediation really helped him move forward.
Client that had come into the office, and we had talked about the case extensively, and through it all, she wasn't willing to submit, and she wanted to take this to trial. And so I looked at mediation as a form of allowing her an opportunity to hear what the other side had to say. And I was hopeful that we would get it resolved, but I wasn't confident that we would. And throughout the course of mediation, it was about, I would say, an hour into it, she finally noticed the issues with her case, and we were able to resolve it. And again, she felt, I think, much more relieved and much more heard than she would have if we would have gone to trial, put her on the stand, and she would have had to testify. So I thought that that was a good story for her.
Because mediation is a non-adversarial environment for the parents, we resolve petitions. We're able to remove or strike some allegations or change words and submit stipulations and orders as opposed to going to a full-blown trial.
At the placement and TPR stage, mediation can create a meaningful dialogue that helps move children to permanency faster.
One case that I will never forget took place between two sets of grandparents. On one side of the table, I had maternal grandparents whose daughter had been murdered. On the other side of the table, I had paternal grandparents whose son was convicted of murdering her. I can't imagine what it took for those grandparents to be able to sit at a table across from one another, but they were willing to do it because of their grandkids. They knew how important it was to find some kind of resolution of who was going to raise these kids and where they were going to be. And they were able to work it out. Those grandparents have kept in touch. This case happened several years ago. They still talk with some of the people involved in the case. The grandkids are thriving. They have relationships with both grandparents. Without mediation, I don't think that conversation ever would have taken place.
In the alternative, on something like a termination petition, there's a chance that you're going to have the prospective adoptive family with the biological family, the family of origin, and a mediation that is well run, that is supported, where my client doesn't feel like the table is loaded against him or her, sets the foundation for a relationship that can be beneficial for my client, for the social worker or prospective adoptive family, and most importantly for the child.
I've had some very, very beautiful mediations where the parents finally decided, after hearing from prospective adoptive parents, seeing how much everyone in the room loved the child or children. I've had parents decide to relinquish based on just coming to the table and meeting and talking about what everyone's there to talk about, and that's children.
I was a mediator in a termination of parental rights case. So when we came into mediation, of course, it wasn't immediate magic. There had to be some warming up and some talking and some invitations to her to let us know what she was thinking. And she told us that she understood she was going to lose. And so that opened the opportunity to talk about what could we create that would fill the need she was trying to fill when she wasn't expecting to win. And we had the prospective adoptive parent who was the foster parent in the waiting room, and she ultimately joined us. And it took several hours, but over those several hours, the two of them spoke to one another. They had never really spoken to one another other than for visits before. And by the end of it, it was clear from what the mother said that her biggest fear was that her daughter would not understand that she loved her and think she had just abandoned her. And by talking to the adoptive mother, the prospective adoptive mother, I think she was reassured that the prospective adoptive mother intended to honor her role, never intended to pretend there hadn't been an adoption and that she was anything other than her adoptive mom. And at the conclusion, one of the most poignant interchanges I've ever seen happened. The birth mother, when I invited them all to say, is there any unfinished business? Is there anything else that will help you? The birth mother asked the adoptive mother, and said, I have a box of the baby's mementos, her early pictures. I'd like to share it with you. If she sees these things as she grows, she will know I wanted her to have them. I will feel she will know I loved her if she has these tangible things. And of course, virtually everyone in the room dissolved in tears. But no court experience can ever allow that. It's not structured in any way that would ever allow that. Mediation allowed us to understand what she really needed. The court process would have trampled on what she really needed and would never have gotten.
Nevada now has a way to bring the mediation process to every judicial district in the state through the Juvenile Dependency Mediation Program. This program allows trained, neutral mediators to be assigned to dependency mediation cases statewide. The program is based on a model used by the Second Judicial District Court. Studies of this program have shown that mediation is an efficient and effective use of time.
The Administrative Office of the Courts contracted with the National Council of Juvenile and Family Court Judges to really ask the question, does mediation matter? And the result was that it does. And it does in some very profound ways. The National Council, in the first study that they did early in 2013, really looked at process as well as outcomes. And with respect to process, the Council found that participants and stakeholders felt that mediation was a wise use of time, that it resulted in agreement most of the time, and that it was time savings for them in preparation and time savings also for the court. The second study looked at outcomes. In that study, which was done in December of 2013, the question really was, does mediation result in different outcomes between mediated and non-mediated cases? And the answer for that was, yes, it does. The impact was that mediation resulted in cases reunifying more quickly than in non-mediated cases. And then the second finding, which is very significant, was that fathers who attended mediation were more likely to participate in subsequent court hearings. So you had two findings that were really noteworthy from this study. The enhanced likelihood of reunification in mediated cases, and secondly, improved parent engagement, specifically fathers.
So I think another important aspect is the time savings that both the public defender's office and the district attorney's office, as well as the court system. And the reason is, if you can resolve the petition via mediation, or if you can resolve any aspect of the case via mediation, then it allows you time saving so that you're not overly burdened with pursuing a case that can get resolved in another way. And because the court and the judicial system is as burdened as it is today, mediation is a critical component of this process, and I believe it should be utilized more.
Mediation makes a difference and enriches the process in dependency cases for all involved.
Since the inception of the program, we've made it a regular practice to survey participants as well as stakeholders at the conclusion of mediation. And the comments that parents give, the feedback provided by stakeholders really paints a picture that mediation has sometimes a significant impact in people's perceptions of the process. So parents, for example, report feeling heard, perhaps for the first time. They often report that they can raise issues in mediation that may be outside of a legal issue, but are important to them. So having a voice and being able to be part of the decision making is really important to parents. The DA has offered the perception that this gives parents a voice in the process. So I think that really describes what some of the benefits of mediation are to the participants in the process.
There's tons of research on ways that you can mediate in a way that is both advocacy and collaboration simultaneously. And I would advocate, as someone who has really found this beneficial for families, that if you have the ability to engage in mediation, look into it. It's interesting research, and it can only make you a better litigator to have more tools in your toolbox.
One of the things that we know about all courtroom proceedings is that process is paramount. That's been empirically shown in literature that people can have an adverse outcome in a courtroom, but how the process went matters. Ultimately, best process for these family cases is not a courtroom at all. It's outside the courtroom. It's in alternative dispute resolution like mediation, where folks' voices can be heard. The same outcome achieved in mediation and the same outcome achieved through a court process can feel 1,000% different to the litigants. And we know that they accept it, they live with it, they follow it differently depending on how they feel about the process.
Anyone involved in the dependency process can ask the court to order mediation. The court will set the time and place for the mediation and send it to the program administrator to assign a mediator.
As the program administrator for the Juvenile Dependency Mediation Program, I'm so excited that we have this opportunity to bring this process statewide. It's an amazing thing to have the means to help children gain safety and stability in their lives.
But there are moments in mediation where magic happens.
With the Juvenile Dependency Mediation Program, Nevada has the chance to become a leader in the dependency process. We owe it to Nevada's children to use every tool available that helps them achieve the permanency they deserve.